Good morning. I'd like to call to order our House Committee on Housing public hearing for Wednesday, February 11th. We are on our 9 a.m. agenda in conference room 430, and it is currently 9:02 a.m. Couple of quick notes before we dive in. We are gonna DM out of order here. It's our triple referral deadline today, so we want to make sure that we get our triple referrals out as soon as we can to give ensure there's adequate time to file those committee reports. So we will be DMing on HB 2611 and HB 2102 before moving on to the rest of our agenda.
And 1710.
No, we're
Oh no,
it's not.
sorry.
Yeah, just those two at the beginning of the agenda. And before we dive into the testimony, just some quick housekeeping notes. We will have a 2-minute time limit per testifier to ensure that we can get through our entire agenda today. We do have to make sure we adjourn prior to the noon floor session. So it's possible that not all testifiers will have the opportunity to testify, but I'm pretty sure we're gonna be okay today. If you're on Zoom, please keep yourself muted and your video off while waiting to testify. The Zoom chat function will allow you to chat with the technical staff only. Please use the chat only for technical issues. Please avoid using any trademarked or copyrighted images. Please refrain from profanity or uncivil behavior. Such behavior may be grounds for removal from the hearing without the ability to rejoin. And as always, just members of the committee and members of the public, I know everybody's passionate and we have some potentially controversial issues on the agenda today. Just everybody, please communicate that passion while remaining respectful. So that said, the first item on the agenda is HB 2611 relating to antitrust. This bill prohibits the use of algorithmic price setting in Hawaii's rental market and requires the Department of the Attorney General to develop and undertake a public education program regarding the prohibition, establishes fines and penalties. Vice Chair for the testimony.
Attorney General's office in opposition.
Yes, good morning. Chair Epsilon, good morning, Vice Chair, members of the committee. My name is Rod Kimura, and with the Department of the Attorney General. Our filed testimony sets forth a number of issues stemming from the language of the bill. Basically, we express concern that the lack of clarity in the bill will raise enforcement issues and legal issues. Importantly, consider the impact of the bill as it's written on some of your constituents, which will make it difficult for landlords and their agents to determine whether and to what extent their activities may expose them to criminal penalties. The penalties include a fine up to $100,000 for an individual or up to $1 million for a corporation, and there is even a provision for 3 years imprisonment. These penalties are imposed for actions that currently make sense. For example, a landlord will typically set their rent based on the costs and expenses they need to recover, and will look at prevailing rents in the vicinity. Data on prevailing rents in the vicinity is easily available without a fee or subscription on the internet from sites such as Rental Source or Zumper. And due to gaps that may be in the information available to a landlord, they may enlist a professional such as a rental agent, property manager, a realtor, or an asset manager for assistance. And they too will likely look at the costs and expenses that need to be recovered and look at prevailing rents as well. Overall, greater clarity is needed to guard against acts that will inadvertently bring exposure to criminal liability and civil liability. And for these reasons, what's stated in our testimony, we recommend that this bill be held. Thank you.
Thank you. Hawaii Civil Rights Commission in support. Hawaii Realtors with comment. (50501) Hawaii and General Strike Hawaii in support. Ho'aloha Project in support. And also 13 individuals in support and 1 in opposition. Anyone online or in person wishing to testify on HB 2611?
Members, any questions? Rep. Kadadari.
For the AGs, thank you so much for your extensive testimony and raising those points. I was wondering, in your testimony, you talk about how a section 480-3 complaint has to allege more than collusory conclusory allegations, but has to set forth enough factual matter to suggest that an agreement was made. Can you elaborate on that and how that might work if a third party is facilitating an agreement?
It's hard to say because it depends on how the suit is brought and who is the alleged defendant. But generally speaking, there are requirements that are attendant to an antitrust action. It's not a matter of just saying party A has been colluding and therefore we're entitled to judgment. That explodes open to an examination of the product market, geographic market, and things of that sort, many of which require expert testimony. You know, it's one of those cases where the antitrust law explodes open with a lot of intricacies and technicalities that the conventional person, the normal person may not know about. As an example, the term tacit agreement. There's a lot of debate over what is a tacit agreement. When I took economics, it wasn't even discussed in economic literature. It's become a vogue, and if you ask a normal person on the street, what is a tacit agreement versus a tacit collusion, I think they'll have some confusing answers for you. And that explains why definitions are needed in this bill to clearly identify what is the conduct that's being proscribed so that someone who's deciding on an enforcement action can decide whether this is worth their time and effort.
Can I ask one more question? I was also wondering, you raised a lot of concerns about definitions, but I was particularly interested in one. Would adding clarity that these coordinating functions apply only between two or more property owners or managers that are not part of the same parent entity or managed by the same property owner or manager, would that address some of those concerns, or is it deeper than that? Like that the practices are happening between competing landlords instead of because I think the language maybe now suggests that it could apply to a landlord who owns multiple properties and is setting prices between those properties.
Okay, so I think what you're getting at is what happens if you have property owner 1 and property owner 2 getting together to make an agreement. Is that what you're getting to?
Yeah.
Well, that would be collusion.
Okay, I think that's not quite my question, but I probably need to think more on it. So thank you. That's good enough for now. Thank you so much. Thanks, Chair.
Thank you. I have a question. So I have a rental unit in my own home. I follow the County of Kauai has a long-term affordable rental program. And they publish rates that to qualify for the program, you have to rent your unit under the published rates. And they're based off of 90% of area median income for the island. And so I have always just used those rates to set my rent at. And I know others who do similar things. I've never colluded with those other people to do so, but we're just following the county's guidelines. And I think technically that county, the 90% AMI is an algorithm of sorts. It's based off a formula. So would me setting rates based off of the county's published rate schedule be unlawful under this bill?
My unofficial opinion is no. It would not be unlawful to do that because you're using basically public information. You haven't colluded with anyone. I mean, it's to give the example of the typical tacit collusion. You've got gas stations on two corners. Each can see what the other is charging. One person goes out of his gas station, looks at the competitor and says, oh, they're charging $3.49. Great, I'm going to charge $3.49. They never communicate. It's public information, easily available. That would not necessarily be condemned under the antitrust law. Now, if they had another agreement that said, look, I'm going to raise my prices. I want you to follow my prices. So just take a look outside and see my signage. And if that's what was going on, that's a whole nother situation.
Okay, thank you. Appreciate that. Members, other questions? Seeing none. Next item on the agenda is HP 2102 related to historic preservation. This bill clarifies that residential projects involving ground disturbance in high-risk areas remains subject to review under the State Historic Preservation Program, removes the historic review exemption for lands presumed nominally sensitive. Vice Chair for the testimony.
State Historic Preservation Division with comments. Thank you. Office of Planning and Sustainable Development and support.
Aloha Chair, Vice Chair, members of the committee, Diana Setness with the Office of Planning and Sustainable Development. LPSD stands on its written testimony in support, and we are open for further questions. Thank you.
Thank you. NIAP Hawaii in opposition.
Good morning, Chair, Vice Chair, members of the committee, Evan Oy on behalf of NIAP Hawaii. We respectfully oppose this bill. While we acknowledge the intent that this bill is trying to accomplish, I think this largely undoes a lot of the progress that we made for on this front just last year. And we did want to note that the process still incorporates protections for inadvertent findings and allowing that to continue while promoting efficiency within the review process and the overall volume that's sent to the department. The definition change as well as the exemptions in 6042 were placed in there to be a more balanced approach and try to reduce review times for lower and nominally sensitive areas. So for those reasons, we respectfully oppose. Thank you.
Thank you. Kailua Hawaiian Civics Club in support. Navaia Ho'ola Nui La'au Lapa'au Foundation in support. Office of Hawaiian Affairs in support.
Aloha Kahiaka, Chair Evelyn and Vice Chair Miyake. Aloha Makuanani on behalf of the Office of Hawaiian Affairs. We're in strong support, but also want to thank the committee for setting this for hearing. This is one of our OHA legislative package bills. We mostly stand on our written comments, but I would like to provide a little bit more context because of our background here and the reason for introducing this bill. We've received a lot of beneficiary complaints about this bill that was passed last year. We were also aware of it at the last minute, so providing some context there. This bill was passed after crossover with late term amendments, so most of the stakeholders caught on late to that process. We did submit letters to the governor and such, and it went onto the veto list, but ultimately did pass. And I think that is relevant here because the amendments that went in are so potentially harmful to iwi kupuna that it has brought out a lot of stakeholders in support of removing some of that language, particularly the nominally sensitive area language, which was drawn from another bill during the same session. What makes it so harmful here compared to where it came from is that in the other one, SHPD was making the determination on whether an area is nominally sensitive or not. And here that is actually done by either proponents or state and county agencies, which don't have that historic preservation experience. The other bill also had consultation requirements and conditions on how those sensitivity determinations are made. And so that's why dropping this language in last minute caused a lot of alarm for all of the stakeholders involved, and why we think it's so important that that be removed. Beyond that, if you have additional questions, we'll be available for a question as well.
Thank you. Native Hawaiian Legal Corporation in support. Shelby Billionaire in support on Zoom. No, not present. Oh,
Aloha guys, how are you? Aloha chairs, how are you? Pikachu Shelby Billionaire representing Ohana Unity Party, King of the Hawaiian Islands. I support this because OHA actually came out from downtown. They came to Waianae board, which is very rare, in the middle of the night. Just this past week, they ran over all the priorities, and one of them is this. They only had 6. So luckily, I testified in this in advance. And through my experience with SHPD, with all these bills and laws in Kukai, I can tell you straight. They found dead bones in Pokai Bay last year. What does DLNR do? When you call them, they'll call Shifty, takes them time. They don't actually dig the bones back. They just cover it back up. So when you discover iwi kupuna on real estate and construction, you're supposed to stop that, call the burial council, call DLNR, and they're supposed to protect that. You put the Hawaiian headstone of your family, Paki, Kalani, whoever it is, and they're supposed to protect that. That's the law, how it's supposed to work with SHPD. Then you file your Hawaiian legal paperwork, your Royal Patent LCA with the Bureau of Conveyance, and that's how Uncle Kemoku taught me. So how you guys work this out together with Native Hawaiian Legal Corporation, Bureau of Conveyance, Auntie Don Chang, D. Lenar, OHA, DHHL. That's up to you guys. So I thank you, appreciate, support the bill, add any amendments you need. Chihu, yeah you, aloha.
Thank you. Bianca Isaki in support. Who? Bianca Isaki,
Not present.
not present. Clarapana Malama Kakani Lua in support on Zoom,
Not present.
not present. We also got 48 individuals in support. Anyone online or in person wishing to testify on HB 2102?
Michael Cat, here on behalf of Department of Planning and Permitting. Uh, The Department of Planning and Permitting offers comments with suggested amendments on House Bill number 2102, which clarifies that residential projects involving ground disturbance in high-risk areas remain subject to review under the State Historic Preservation Program, and removes the historic review exemption for lands presumed nominally sensitive. DPP recognizes the importance of ensuring that projects with potential to affect historic properties and EV Kapuna receive appropriate review. At the same time, we are mindful of the State Historic Preservation Division's current capacity constraints and need to avoid creating additional review backlogs that could delay housing and other residential projects. Recent statutory changes have created uncertainty for both agencies and applicants regarding when residential projects should be routed for review. Greater clarity and predictability would benefit implementation and help ensure that review is focused on projects that present the greatest potential risk, particularly those involving ground disturbing activities in sensitive areas. As this measure moves forward, DPP encourages consideration of an approach that balances the need for meaningful historic preservation review with practical realities of agency capacity and timely delivery of housing. We recommend one clarifying edit to section 6E 42.2A, paragraph 2A, to read occurs on or adjacent to land containing sandy soil and. This revision would more clearly identify lands containing sandy soils that are culturally sensitive in relation to features identified in item B, and would support more consistent interpretation and application. Thank you for the opportunity to testify. I'm here for any comment or questions that you have. Thank you.
Thank you. Anyone else online or in person wishing to testify on HB 2102?
Thank you.
Seeing none, Chair.
Members, any questions? I have a question for Shipti. Hi Jessica, thank you for being here. Could you walk us through what nominally sensitive means and the work that you guys are doing to further define or map out what areas are nominally sensitive?
So based on the definitions passed last year of nominally sensitive, Shipti's been working particularly with DPP and Maui County to identify areas that are less likely to encounter historic properties or EV Kapuna under the ground. And this classification is nominally sensitive. We've interpreted it to mean that we determine which locations are less likely to have EV Kapuna or historic properties under the ground based on previous survey data, based on previous archaeological monitoring reports, and based on previous projects to determine if anything has been found during the execution of survey monitoring or projects. So and then using that data, it creates a sensitivity map that shows that these parcels of land or TMKs are less likely and therefore are determined to have historic properties and therefore are nominally sensitive. So internally, that's how we determine nominal sensitivity. And like I said, we've been working with particularly Maui County and City and County of Honolulu to make sure that our data matches up. So our GIS maps match up with their GIS maps, which is a mapping program that we all use to determine like sensitivity and stuff like that based on where historic sites are found or EV component.
And is that work still ongoing, or have you guys, are the maps being utilized currently?
I believe so. I mean, we're still working on them. And we're focusing right now our efforts with Maui County and City and County of Honolulu on Lahaina because of all the recovery work going on and trying to streamline that process so that survivors can get back home as quickly as possible. And then also with DPP, places that are most sensitive, like Kailua, for example, to make sure that property owners are aware of what's on their property when they go to develop and the need to come to shift deed to take into account the likelihood of encounter EV. But then also we've been talking about places like City and County of Honolulu, like Magic Island, that we know is nominally sensitive. There's pretty much nothing there. And we've determined that based on, like I said, past projects, archaeological surveys, stuff like that.
And we got a number of testimonies that described a story in Kailua where it sounds like there was an excavation of a swimming pool and there were inadvertent discovery of 4 iwi kupuna in the area. And the testimony said that the area was considered nominally sensitive. And so it's part of the argument for why the nominally sensitive definition should go away. You had just said that, you know, Kailua is a highly sensitive area. So could you clarify whether Kailua is nominally sensitive or not, and maybe how that determination might have been made or not made?
Yeah, Kailua is not nominally sensitive. It's the opposite of nominally sensitive. We know based on past projects, survey data, monitoring, all of that, it is a highly sensitive area. There are a number of individuals who are buried there. My best guess of why a project might have moved forward is likely due to the exemptions passed last session and misinterpretation perhaps at DPP by someone who was handling a permit to understand the sensitivity of that area. So it might have just been human error. And that does happen, but we would like it not. We would all like it not to happen ever, but I do understand that sometimes things happen. But yeah, in that case, and in many other cases, we anticipate that yes, almost every project that happens in Kailua has a very high chance of encountering EV when you're doing ground disturbance.
And OHA brought up in their testimony that it's potentially problematic that the nominally sensitive areas can be defined by you guys or by the planning agencies or possibly by project proponents. So I guess could you clarify whether a project proponent could just say, oh, this is nominally sensitive, it doesn't need further review? How would that work?
I think in the wording of the language under 6042.2, I can understand why it would be interpreted that an individual might, like a project proponent, might be able to determine their property to be nominally sensitive. There was another bill passed last session that allows certified, I can't remember the language, but self-certification for individuals to self-certify that a property would result in no historic properties affected when they go through the permitting review process. So I think that there is theoretically a framework for a bad actor to come along and self-certify that their property or the property that they're hired to work on is in a nominally sensitive area and would result in no historic properties affected. I think one way to resolve that is to tighten up the language throughout 60 to specify that nominally sensitive areas are determined by the State Historic Preservation Division in coordination with the counties. that might be one way to resolve that issue, but I would wanna talk to OHA and the counties just to make sure that that was language they were comfortable with.
Okay. 1 second, let me just finish writing that. And then, given that you're mapping this out currently in what sounds like a shared resource between you folks and the counties, how likely is it going forward that counties will make a determination that, say, a highly sensitive area is highly sensitive area is nominal?
I think that's hard to predict. I think that as long as we are all sharing the same data and working off the same data and are interpreting the same data in the same way, that it will minimize the potential for human error or a misinterpretation to happen. So I can't give you an exact percentage, but I think that as long as we're continuing to be in this agreement where we're sharing the same data and the same interpretations, that'll definitely lessen the possibility for an area that we all agree to be nominally sensitive or not sensitive, and not mistake a highly sensitive area for an area that's nominally sensitive or has no sensitivity at all because there's nothing there.
And then in your testimony, you suggested some amendments, one of which includes adding language around high density residential properties. Which seems like it would infer that excluded activities could include high density properties as long as
There's no ground disturbance.
no ground
Yeah.
disturbance. And could you talk through the rationale, or maybe the current determination and whether high density is included or not in the definition of excluded, and then why you think high density should be added and how this would be applied?
Okay, so if we're going based off on the 6042.2 language that exists now before any amendments, it's limited to existing privately owned single-family detached dwelling unit, townhome, and I can't remember. I'm looking at a bill that's got crosses out, but it's like single-family residential dwelling, townhome, and then there was another language category. But that it didn't include, and because it didn't include, the assumption is that it's not a property type of a high density property is not eligible for this exemption. But it SHPD's determination that a high density, say, condo unit that exists right now should be equally eligible for an exemption on this for anything from routine maintenance and repair to renovations of condo units to things that the HOA has to regularly do, like if they have to replace an elevator or something like that. Anything that might trigger a building permit from the county and those building types should also be eligible for the exemption, not because the exemption exists, but because those activities are the type that would not adversely affect a historic property and are already in keeping with SOI standards. Unless they're gonna tear the entire building down, there's very little that you can do to a high density building that would make it ineligible for listing, and therefore those are project types that it would be fine for them to be exempted.
Thank you. And what if there was ground disturbance, just no deeper than like the original foundation?
Yeah, so if there was ground disturbing activities for a high density property, say for example, a condo unit has a swimming pool, but they have to redig for a swimming pool. If they stayed within the existing swimming pool's depth, like if they were putting a new liner in or something like that, or doing some plumbing repairs, and they stayed within the area of previous ground disturbance, they would likely be okay. The only exception to that might be is if they're in a high sensitive area.
Yeah.
In which case, one of the other triggers would, based on OHA's bill, would require that property to come to SHPD for review.
And just to be clear, you said they'll likely be okay, meaning you think that they likely should be included as in the list of excluded activities.
Exactly.
Okay, members, thank you, Jessica. Further questions?
How many instances will it take, or does it take, for you guys to identify an area as sensitive?
How many instances?
Of findings.
It's not necessarily per se the instances, it might be the type of finding. So in archaeology, if you find, say, we were just having this conversation with the Navy this morning, where they were doing archaeological monitoring for a project and they found a historic dog tag in the soil. That dog tag that they found would not necessarily constitute a remapping of that area to be highly sensitive. That could have just been because an individual's dog tag fell off when they were doing work. So it depends. When it comes to EV, however, that is different. So an individual who is found subsurface, EV Kapuna, one individual makes that property highly sensitive. Because if you find one individual, the likelihood of finding another individual is very high, either on the same parcel or within a very close proximity to that individual on another parcel neighboring.
The reason I asked that is you've seen testimony from Pikachu. I was there that day that they found the skull. They notified, they verified, Shipty came out, and it was verified that it is Ivi Kupuna. They also even contacted family members which came out and identified the area as the Kila family burial dunes. Till today, this was over 5 months ago, till today there's nothing been done yet. They haven't come out, they haven't put cones, fencing, signage, anything. Yet it still remains unopened. The HPD still runs it over every day with their UTVs while doing their surveillance. So how many instances does it take for something like that to demand attention? Secondly, right across the street from that area, they're planning on building homes. Up to 24 homes is what the developer talked about when they came to the neighborhood board. So maybe this isn't the place to get the answers. Maybe you want to come to my office later on and we can talk more in depth about the situation. But to identify an area that's sensitive, you know, where can they find mapping? Can we find mapping that we might be able to talk to this developer that his area is potentially a sensitive area?
Yeah, that, I would have to look more into it to see exactly what is going on with that burial. We definitely should not have burials that are open or in a situation where they can be damaged. In those instances, I will put it this way. Best practices in consultation with many descendants is to try to preserve EV component in place. And so if EV is found, say because of coastal erosion or because it's in a high trafficked area or something like that, we try to preserve the EV in place on the site. And so we might cover until we coordinate with descendants and the burial council rep for that region on what to do in terms of preserving the EV in place or trying to find a new location for it to be reinterred at based on like the safety of the site. So yes, I could see our staff leaving a burial in place, but if it's in a unsafe location, meaning that it could be disturbed or damaged or whatever, our staff should be removing that individual to a protected location, either on site or with a descendant, or in the last case scenario, to have Shipty remove that individual to a safe, secure spot until it can be reinterred. So yeah, I'll follow up with them on that situation because that doesn't sound right.
If you can, I don't mean to hijack it, but it's just that I was there that day, homeless individual digging whatever, picked up the skull. Family came down, they took it out, took possession of it. I waited on site, DLNR, Shipty came, did their thing, nothing was done. We looked at the area and then they walked. I sent emails, I sent several emails to DLNR Shipty, got no response. Until today, there was nothing done. This is highly trafficked area and, you know, we can meet later on and I can give you more details if you need.
Sorry, Jessica, one more question.
Yeah.
DPP offered a proposed amendment to say, instead of the current language of the bill, which says occurs on or adjacent to land containing sandy soils, or the ground disturbing activity exceeds excavation and has previous identified burials, et cetera, they're suggesting instead of or, that would be and, that both would have to apply. Essentially sandy soil and previous findings in the area. Could I have your thoughts on that proposed amendment?
I think that amendment is likely reasonable. We do have properties where there are sandy soil that have been previously identified because the soil has been infilled. Soil has been so there are properties that are sandy. I'll put it through this logic. There are properties with sandy soil where they are nominally sensitive properties or properties that don't have historic properties or likely don't have historic properties or EV component in it. So I think adding language to that effect can be reasonable to tailor down to take into account those properties with sandy soil that don't have historic properties or EV component on them. So I think yes, that kind of an edit is likely reasonable. Yeah.
Okay, thank you. Rep. Cochran.
Hi, good morning, hi, nice to see you, sorry for my tardiness. So in your testimony, you did mention you've been working with County of Maui, in what way?
We meet with them every week or every other week, but most recently we've been meeting with Maui County to develop what's called a memorandum of understanding to help facilitate the 6E review process for property owners who have to rebuild in Lahaina. That MOU would help to establish a set of archaeological monitoring provisions that are preset so that a property owner doesn't have to hire an archaeologist or consultant to either one, do an archaeological inventory survey before rebuild, or to hire someone to write archaeological monitoring provisions. They would only need to potentially contract with an archaeological monitor to watch the ground disturbing activities while they rebuild. And those requirements are put into place in certain circumstances where projects may be, like a family might be reconstructing their house, but adding square footage. For example, that property owner might have to do archaeological monitoring, but if you were rebuilding in the existing footprint of your house, you might not. So it's building out the framework for that to expedite permits and reconstruction so that property owners aren't in, the whole inspiration of it is so that property owners aren't potentially losing out on insurance money or any kind of funding that might be available to them to rebuild. So we're trying to figure out ways that we can expedite while still taking into consideration the high sensitivity of that area and the likelihood of encountering EV.
Okay, and one follow-up. And so is it a mandatory thing, this, what you're saying, in the Lahaina Historic District itself? Just, you know, because it's the historic district, one, and then any place, anywhere's outside of it, basically above Honoapi'ilani, you know, Highway 30, then there's where, you know, there's maybe not needed for the survey.
Yeah, so we're using survey data that was collected by FEMA during debris removal and the initial recovery or emergency response, debris removal, and now into the construction phase. There's a bunch of data that FEMA has collected that we're using to develop sensitivity maps for the burn scar area. Some of that data does include sites above Honoapi'ilani Highway, but the sensitivity of that area is slightly different, where it's not necessarily that we're encountering EV, we're more likely encountering historic sites like Heiau and things like that. And we have a lot of good data on that, not from the recovery project, but because of the Honoapi'ilani Highway project. So we have good data to help streamline reconstruction projects due to those two efforts.
Okay, thank you. And just one last, this portion about existing privately owned properties, is this enhancing more oversight or giving them a little more leeway? I'm just trying to figure that out for this portion about excluded activities for existing privately owned properties.
I think that trying to figure out, like, if it's a category all in of itself, if it's an existing privately owned property and they're keeping the project type to the restricted types that are allowed under this bill in terms of ground disturbance, or under 6042.2 as it's currently defined. I think that what OHA is proposing in terms of adding these restrictions restricts the type of residential properties, existing residential property types that are exempted. So I don't know if this is answering your question. So it doesn't allow for just any existing residential property or any residential property from being exempted from 6042. It's saying that in these areas, you're likely going to encounter something, and particularly EV, and because of that, you have to come to SHPE. You're no longer exempted. So I think it pulls back the exemption on certain property types that likely will encounter a historic property, or like I said, more importantly, EV Kapuna.
Okay, yeah, no, that's good. Thank you for your time. Thank you, Chair.
Thank you, Jessica. I have a question for DPP. Two related questions. So I think you probably heard my question to Jessica regarding testimony that's told a story about potential declaration of an area as anomaly sensitive in Kailua. Do you know the details of that and whether DPP made that determination, and was that actually considered anomaly sensitive or what happened?
It wasn't considered anomaly sensitive. So the issue with that is how our systems interact with the data that we get from SHPE. And so we are reliant on warnings and advisories to inform us of when something has burials or archaeological resources on that site or even adjacent. But even when we put buffers or try to, do our best effort to flag properties for that review, sometimes things get missed. And we've been working to try and sync our data up with SHPE's. We've been getting new data every few months or so and trying to integrate that into our system as best we can. But unfortunately, sometimes things get missed.
Thank you. And so as it relates to this bill and our determination of whether to delete the definitions of anomaly sensitive, just so I'm totally clear, you're saying that the definition of anomaly sensitive was added to statute last year was not a factor in the EV component that was found in Kailua?
No, it wasn't. It's been really hard to interpret what that exactly means because there's a lot of ambiguity in that definition, and we understand the intent, but it's hard for us to make that kind of call. We've had applicants certainly ask about it, but no one has, to my knowledge, tried to implement that.
Okay, so DPP is then relying on SHPE's determination of anomaly. You're not making your own determination.
Even if an applicant submits to us, we still have the opportunity to make that decision as whether or not we agree, and then we can to SHPE.
Okay, and the last question, you gave us a proposed amendment, which I appreciate. What are your thoughts on the bill as written, which deletes the definition of anomaly sensitive and would delete the exemption for anomaly sensitive areas?
I think, if we're deleting that and taking on these new amendments, then it's at least a step in the right direction to try to get to that intent of trying to find that middle ground of which projects require review and those that probably have low risk.
Okay. Okay, thank you. Members, further questions? Yeah, we're all go.
Same question I asked SHPE. How many do you folks, are you aware of that? Excuse me, not the same question, but are you aware of the situation I asked SHPE?
A little bit.
You are. So did that, I don't know if this is a right question, Chair, excuse me if did that permit for those homes in that area come through yet, and is it flagged? Was it flagged?
Sorry, I thought you meant about the beach, but I'm not certain if there's an advisory, but I certainly could follow up with you outside to check about that.
Thank you.
Thank you. Members, further questions? Okay, seeing none, we are going to recess. Again, we're taking these items out of order. So we'll be voting decision making on HB 2611 and HB 2102 momentarily, but I want to recess to give members a chance to get here from Pro. Recess. reconvening the House Housing Committee for our 9 AM agenda for decision making on 2 items only. We're taking this out of order, so we're DMing on HB 2611 and HB 2102, and then we'll take up the rest of our agenda after that. First item on the agenda, HB 2611 relating to antitrust. I appreciate the introducer's work on this. I appreciate the intention of the bill. On first read, when I saw it, I thought this seems, logical. However, based on the Attorney General's comments, it does seem like there has to be a lot of work done to make this work, make it not overly broad, and make it, ensure that we can enforce it. So that said, my hope is that the introducer, could maybe do more work on this and we can look at it again for next year. So we will be deferring that bill, but I did want to give an opportunity to any members, including the introducer, to make any comments if you want.
Thank you, Chair. Thank you for hearing the bill. Yeah, there's a lot of really helpful testimony from the AG, and I just also wanted to share that the language was based heavily on successful legislation from New York. Places like New York, California, cities around the country are taking the lead against algorithmic price fixing, and it's a problem that's not going to go away. It's been recognized by the DOJ, subject of several federal lawsuits, and it's been extensively reported. The VP of RealPage, one of the leading companies that facilitates this kind of price fixing, has publicly claimed or said that their software has driven double-digit year-over-year rent increases in some places, and they've some of their clients have seen turnover rates increase by 15%. So I think that one thing that stood out to me is in the AG's testimony was that the term tacit agreement is becoming so prevalent, and I think that that is because there's a lag between antitrust law and these technological advancements that allow corporate landlords and these tech companies to essentially raise prices and compound our existing affordability crisis. So I find that really concerning, but I acknowledge there's a ton of work to do, so I totally support your decision to defer, and I look forward to doing more work on this bill and also tracking the settlements that are happening and the federal government's willingness to enforce them, and then hopefully being able to take more decisive action. Thank you so much.
Thank you, Representative Kennedy. Other members want to comment?
I just wanted to appreciate and send my mahalo to the introducer. When it comes to situations like this, my community takes a big hit. Yeah, and then, when we lose the sensitivity of large investors, they don't even pay attention. They buy these things, they don't monitor, it's just they send it off to a management company. And over time, it just becomes so unaffordable and they don't really. So just my appreciation to the introducer for the intent of it.
Thanks, Rep. Morelka. Rep. Cochran?
Yeah, thank you. Do we know if HUD and FEMA utilize these types of algorithms, especially after disasters? Because there's a really bad situation that's occurred in Lahaina since the fire in regards to rents and the pricing. And then they point the figures back at the state, said they got their figures from the state. So, example is studios they paid studio owners $5,000. 3 bedrooms, they paid people $16,000. Now that the the fire's, kind of few years down the road, these homeowners, landowners want that same amount of money and talk about being priced out of paradise. This is happening. But I'm just wondering where this algorithm thing maybe comes into play here somehow. I don't know. Do you?
I don't necessarily want to have a long discussion on this, but
that was just my,
appreciate it, yeah.
So thank you for the deferral, because there needs to be work.
Thank you, Representative Cochran. Okay, seeing no further comments, that measure is deferred. Next item on the agenda is HB 2102 relating to historic preservation. I want to thank all the testifiers. We got a lot of testimony on this. I want to thank OHA for their work on this bill. And I want to thank SHPT and DPP and everybody else who came out. We are going to move it forward with an HD1, but just a little bit of context. Last year, there were a number of SHPT related bills, I believe 4. And the reason for that as I understood, was I think there's broad recognition that SHPD is has been traditionally overburdened. We are sending a lot of permits to SHPD for review. Every 50-year-old culvert was getting sent to SHPD for review. Review times could be, as I've heard, 6 months best case scenario, but up to 3 years plus, sometimes in some outliers. A lot of projects, I'm hearing of a project on Kauai right now in sandy soil. They're just trying to build a fence. They need to do 100% AIS for that. It's $10,000 to auger some holes in the ground. And so I think, based on recognition of SHPD being overburdened, that we're sending too much to them, and maybe the overbroad definitions that we had in statute. I think the legislature recognized last year that we needed to try and figure out some reasonable ways to curtail what we were sending to SHPD while still doing our best to protect sensitive historic areas in EV Kapuna. At the same time as trying to ensure that SHPD can staff up, right? I think it's kind of a multifold approach. And the change in the definition to historic was one of them. The expansion of excluded activities was one of them, right? The definition of nominally sensitive was one of those things. And I do want to recognize OHA's concerns here, that it's possible that some of what we did might have opened the door too much, and we need to ensure that we are protecting EV Kapuna. At the same time, I want to ensure that we can let the process of defining nominally sensitive play out here. I think it's too early to try and walk this back, as they're still going through the work of mapping this out and determining what is nominally sensitive or not. And so all that said, I'm going to move forward the bill with some comprehensive amendments. I'm going to go through those amendments in a second, but the gist of it is we're going to retain the definition of nominally sensitive. We're going to keep the language in the bill for further defining that if something is on sandy soil and in an area with previous findings, that this is not excluded from further SHPD review. So I think the core of that will continue to move forward for further discussion. And also taking up some of SHPD's amendments relating to higher density. So I'm going to go through it right now. Members, if you have questions afterwards, happy to talk through and explain some of the changes that I made. So again, recommending that move out in HD1. We'll be deleting paragraphs 2 and 3 of the preamble. Delete existing on page 3, line 8. Delete low unit on page 3, line 10. Delete low unit on page 3, line 13. Move paragraph 1 on page 3, line 17 into the end of subsection A. Page 4, line 3, add quote local, state, or nationally designated. We'll be clarifying that both A and B must occur in paragraph 2 on page 4, and this is from DPP's testimony. Remove lava tubes, karst features, or caves under clause 2 on page 4 to subparagraph A. So that will read, and delete adjacent on line 6. So that will read, paragraph A will read, occurs on land containing sandy soil, lava tubes, karst features, or caves. Adopt the language from SHPD's testimony as it relates to clause 3 under subparagraph B. Expand the list of projects that would trigger 60-42 review to include language showing that the proposed project contains 5 or more dwelling units and ground disturbing activity is deeper than the depth of the deepest existing foundation on the parcel. And we're adding that because we're opening up the excluded activities to include higher density projects. So we just want to put some boundaries on when the exclusion would apply to higher density projects. So if, as Jessica said, you're just doing renovations of the interior of a apartment complex, it wouldn't go to SHPD for review. If they're doing extensive ground disturbance, it would. Reinstate the exemption and the definition of nominally sensitive areas to the language that currently exists in statute. Delete the definition of existing privately owned low unit residential property. This is because we're no longer narrowly doing that just for low unit. So we're taking that definition out. Tech amendments as necessary, and we will defect the date. Hold on one second. Sorry, and then also in the, as we restate the exemption and the definition of nominally sensitive areas, we will clarify that that definition is determined by SHPD in coordination with the counties. And then we'll give SHPD rulemaking authority if they need to further refine and implement this. I think I said it already, but tech amendments and defective date. Members, any questions? I know that was a lot.
Sure.
Yes, Rep. Cochran.
In reference, can you reiterate the Sandy portion, what you're
Yes.
changing there?
Good question. So we are going to take DPP's proposal where we will say that essentially if a project involves, so page 4. So see us currently in page 4, paragraph 2 or subsection 2. The proposed project involves ground disturbing activity and occurs on or adjacent to land containing sandy soils, or the ground disturbing activity exceeds the excavation of topsoil and occurs on or adjacent to land that contains previously identified burials or cemeteries. What we are saying is that a project won't be eligible for, as an excluded activity if it occurs on land containing sandy soils, lava tubes, karst features, or caves, and the ground disturbing activity exceeds the excavation of topsoil and occurs on or adjacent to land that contains previously identified burials or cemeteries, or property previously determined to be significant under criteria E. So, right, so we're saying it has to be on sandy soil and have previous findings near it to not be excluded.
Okay, good.
Make sense?
Yeah.
Okay. And lastly, I want to say we made some big changes here. This is the first committee. I'm sure there'll be more work to be done on this bill. It will likely have 5 more hearings if it's going to pass out of the legislature. So there's plenty of more opportunities for input and for modifications. I think, as we all recognize as we're going through this, anything relating to SHPD gets extremely complicated, extremely fast, and we want to make sure that we're not, that we're making the process better here. So encourage advocates to continue and stay engaged, and that's all. Members, final comments before we vote? Okay, thank you again, members. Vice Chair for the vote.
Voting on HB 2102, the recommendation is to pass with amendments. Chair and Vice Chair vote aye. Representative Cochran.
Aye.
Representative Grandinetti.
Aye.
Representative Keela is excused. Representative Kitagawa.
Aye.
Representative Lachika.
Aye.
Representative Muraoka.
Aye.
Representative Perry. Alright. The recommendation is adopted.
Thank you. Okay, back to our regular agenda. Actually, we'll take a quick recess. Reconvening the Housing Committee hearing, we are still on our 9 AM agenda, we are on the third bill on our agenda. HB 1710 HD1 relating to historic preservation. This bill authorizes SHPD to conduct a phased review of a proposed project on private property under certain circumstances. Amends the process and deadlines by which SHPD must provide written concurrence or non-concurrence for proposed projects on private property or certain projects that require state or county approval for entitlement for use, after which a concurrence may be assumed and the project may proceed. Vice Chair for the testimony.
State Historic Preservation Division in support. Thank you. Hawaii Office of Recovery and Resiliency in support. Office of Planning and Sustainable Development in support.
Aloha, Chair, Vice Chair, members of the committee, Diana Senes with the Office of Planning and Sustainable Development. OPSD stands on its written testimony and support, and we are available for any questions.
Thank you. Kauai Council Member Addison Bulusan in support. Department of Planning and Permitting in support. Hawaii Realtors in support.
Thank you, we stand on our testimony and support.
Thank you. NIAP Hawaii in support. Thanks, we stand on our testimony. Thank you. ABC Stores in support. Hawaii Lesed, Laborers, Employers, Cooperation and Education Trust in support. General Contractors Association of Hawaii in support. The Gallery Limited in support. Housing Hawaii's Future in support. AARP Hawaii in support. Present. Avalon Development in support. Grassroots Institute of Hawaii in support. Office of Hawaiian Affairs with comments.
Aloha Chair, Vice Chair, members of the committee, Kamakana Ferreira, the compliance archaeologist with the Office of Hawaiian Affairs. We stand on a written testimony that's providing comments on this bill, but a few highlights. So first, we are really appreciative of the language about a complete submittal. That is something that we have advocated for in the past. There's a lot of blame going to SHPD about there being delays, but there's a lot of submittals that are completed that just don't have basic information. I mean, a lot of our office, we send out RFIs all the time. It's the majority of emails that we send out statistically, and it's because of incomplete submittals. So we are really appreciative of that language here. Second, in the HD1 version, in the first hearing, it was our impression that the 30-day concurrence was going to be removed from both 6E42 and 6E10. But it looks like it was only removed from 6E42, and we would recommend that it also be applied to 6E10 because there is some uncertainty on who's making the determination of what's when there's no historic properties affected. And then lastly, we still have some issues with the language about phased review, mostly because 6E42 already has language for phased review. And if the intent truly is for preservation purposes like maintenance actions or repairs, for projects that don't require permits, we have some suggested amendment language that perhaps the project proponent should consider a preservation plan, which is governed under 13-77, which sets out maintenance intervals and also allows for a certain form of construction related to preservation. The problem is that preservation plans are usually only allowed when there's a permitted activity. So SHPD won't review proactive preservation plans. So if this language was inserted, it would allow those proactive efforts to go forward. That's all we have. They're available for any questions. Thank you.
Thank you. HGEA in support. Stanford Car Development in support. And 7 individuals in support. Anyone online or in person wishing to testify on HB 1710? Oh, please.
Chair, Vice Chair, members of the committee. HCDA, so as HCDA we haven't taken an official position. We will follow up on the bill, and as a member of the Speed Task Force, I can mention that this bill interacts and generates an instrument for what we have been discussing at the building permit group as well as in the 6E peak of the speed task force. So we see it.
Thank you. Could you just state your name for the record?
Martin Ancelini,
Thank you very much.
HCDL.
Thank you. Anyone else online or in person wishing to testify on HB 1710? Seeing none, Chair.
Members, any questions? Quick question for OHA. Could you just clarify why you folks are concerned with the 30-day concurrence for properties if there's no historic?
We're worried about like who's making that determination, cause there have been times where we've reviewed applications and the project proponent will assert that no historic properties are affected. So if that's the assertion and they're looking for a 30-day concurrence, oftentimes that assertion is being made without review by historic preservation personnel or any evidence to support that conclusion.
Okay, thank you. Jessica? I know that the 30-day language was passed last year in a separate bill in another section. What are your thoughts on OHA's concerns around the language?
I understand OHA's concerns about who's making the determination of no historic properties affected, especially in a submittal that comes to us. Oftentimes, depending on where it comes from, it might be made by the county or it might be made by the project proponent. Different counties do things differently. I will say that the 30-day determination is already in the process, both in the 6042 and 68 rules, where SHPD within the first initial 30 days is supposed to make a determination of no historic properties affected or ask for more information, and I believe that's where that 30 days is coming from. I think OHA's concern with it then, as the language in this bill states, that if after those 30 days, a project proponent could assume concurrence with the no historic properties affected determination, I can understand their concern with that being the trigger, but I can't say how to resolve that at this moment in time. I think I'd have to look at the language again on if the assumed concurrence comes into play after those initial 30 days or after the totality of, what is it, 120 if you add 90 plus 30 together? 30 day and then 90 day, I'm not sure.
Okay, so just back up 1 second. So the 30 days is currently in your rules. So we are just putting in statute what's in the rule.
Yeah.
I'm a little confused, I guess, on the 90 days. If the department fails to provide written concurrence or non-concurrence within 90 calendar days or within 30 calendar days, if no historic properties are adversely affected by the proposed project. I don't see how those would be added together.
Oh yeah, you're right. Never mind.
Okay, so it's 90.
Yeah, it's 90 days total if so it's the way that the rules are is within the first 30 days we're supposed to either concur with the determination of no historic properties affected. Yeah, I had this flipped in my head. Or ask for more information like an AIS or an RLS or an archaeological inventory survey or a reconnaissance level architectural survey, because the submittal is incomplete and we don't have enough information to determine if there's historic properties or not. And then once we receive that information, we have a further 60 days to review those documents, concur with their finding, and then determine whether or not mitigation is appropriate.
Okay.
And then settle on that.
Makes sense.
Yeah.
Thank you, Jessica.
Sorry, question.
Rep me off. Vice Chair me off.
Thank you, Chair. Thank you, Jessica. I know this was a bill, just wanted to share with the committee that it was a speed task force priority, right? Like we worked on it during the speed task force. And that language, you're right, Chair, it is from the admin rules. But the bill also allows you an extra 5 days for intake, correct?
Yeah. Yeah.
Meaning your staff will review, there's a definition for complete submittal
Yeah.
in chapter 6E. And following the complete submittal, the division will have 5 days if this law passes to intake for your staff to upload onto HiCRIS, et cetera.
And just to certify that at least the initial submittal is complete and that it isn't uploaded with a bunch of misinformation or blank documents or incomplete.
Right, so any back and forth should happen before that period, correct? Like if it's incomplete submittal.
Yeah, so within that first 5 days, I believe what we were talking about in Speed Task Force is our intake specialist will assert that the basic requirements that are in our rules of having like the project scope of work, the permit set of the drawings, your 60 application form, and your permit application form is all submitted, so we can use that information to assess whether or not we need like an AIS or an RLS or something like that.
Okay. So are you comfortable to reinstate that 30 days back since it's in your rules, like the exact language we took out of the admin rules and we added it into here? Right, and based on the discussions from the Speed Task Force.
Yeah, I'm fine with it being included in.
Okay. Perfect. Thank you, appreciate it.
Thank you.
Chair.
Members, further questions?
Sure.
Representative Cochran.
Sure. There's so many dates and timelines in here and it seems like for different things. I mean, I don't know if some of this is pointing to the rail project. If it's pointing to, you know, I'm just trying, is this submitted by you, Vice Chair?
Yes, this was, I was the introducer, but this is a bill from the Speed Task Force, which was unanimously approved by the Speed Task Force members that we worked on this interim.
Right.
And just Rep. Cochran, if you have questions for the testifiers, we can take those now. If you have, I'm open to having, if you have questions on the intent of the bill or to the introducer, we can take those at the end when we're doing decision making. If you're okay with that, just so we can keep moving.
Yeah, good.
Okay, thank you. Members, further questions? Seeing none, next item on the agenda is HB 1868 related to housing. This, among many other things, establishes a working group to revise the Hawaii Housing Finance and Development Corporation's QAP. Vice Chair for the testimony.
Hawaii Public Housing Authority in support.
HPHA stands on its testimony in support.
Thank you. HHFDC with comments.
Chair, Vice Chair, members, Dean Minakami, Hawaii Housing Finance Development Corporation. We do have concerns about this bill. The QAP sets forth the criteria by which, you know, federal tax credits are allocated for local housing tax credit projects. We update the QAP with a qualified allocation plan every year or 2 years sometimes to address needs or comments by stakeholders. We go through a public, transparent process. We have stakeholder meetings to get input and to vet input. So if the legislature wants to create a task force, that's fine. What we're concerned about are sections 3 and 4 of the bill, where language changes to the QAP. So this is putting the cart before the horse. You're mandating changes before you even have a working group, before you even have input. So that is our concern with the bill.
Thank you. Catholic Charities Hawaii with comments on Zoom.
Chair, can you hear me?
Yes.
Okay, I don't know if you can see me, but okay, you can. This is Betty Lou Larson from Catholic Charities Hawaii. We provided comments. We'll stand on our comments and request that you defer this bill due to the comments. Thank you.
Thank you. NIOP Hawaii in opposition.
We sent our testimony in opposition.
Thank you. And one individual with comments. Anyone else online or in person wishing to testify on HB 1868? Seeing none, Chair.
Members, any questions?
This 1868?
Representative La Chica, yeah.
Yes, Dean Case, HHFDC. Do you know for the perpetual affordability like requirement, how many if this were to be mandated, like how many projects this could potentially like affect or would not be able to proceed?
Perpetual affordability is not something we oppose per se, but we do have concerns about how projects will be maintained in the long term. Because these light tech projects, they don't generate enough revenue to pay for capital expenses, you know, in the long run. So this past year, we did incorporate into our criteria that projects could up to commit to perpetual affordability. And a number of projects did commit to that. And so about half of the units that were awarded were government projects where, you know, they may not be committing to perpetual affordability, but they're government projects, so they likely will be, or private projects that did commit to perpetual affordability. Our concern still is though that some of those developers don't have a long-term plan to maintain their property in the long run.
Do you have that data on like at least the number of units or number of projects that did commit to perpetual affordability?
I can provide that to you.
Do you know if the scoring criteria for perpetual affordability is given more weight than the other types of
It
criteria?
is given the most points under affordability commitment.
And then what is the current process that you undergo right now to either change or update the QAP scoring criteria?
This past year, our board formed a PIG to gather stakeholder input. We had also several public meetings with stakeholders. Then we had our board considered changes to the QAP at our board meeting, published a draft QAP, got comments on that. And then it goes after public hearing, it gets adopted by the board, then goes to the governor for approval. So we've had different processes in the past. We haven't had a PIG, we just had stakeholder meetings. So it's been done several different ways in the past.
Is it like a formal process that happens once a year, or is there no?
It's not always once a year. In the past, it's been more like once or every other year. The past, I think, 2 years it was, we amended it twice.
The final question, check. To your knowledge, do you know if there's any other states that have figured out a way to mandate that as part of their
Perpetual affordability?
financing? Yeah.
I believe there's only one state, I think it's Vermont, but they only have perpetual affordability for what's called the 9% projects.
Nine?
There's 4% and 9% by tech projects, so it's only for the 9% projects that they require perpetual affordability. Most of our projects here are 4% projects. We have a handful of 9% projects and those are called the 4% projects.
They tied it to their light tech.
Yes.
Thank you. Thank you, Chair.
Thanks for the questions. Quick question. So you said in the beginning that most projects don't have the revenue to cover capital improvements, and in that case, like, what is your expectation of what will happen to these privately developed projects that have a permanent affordability imposition on them at the end of their 6-year affordability period?
Well, if they commit to perpetual affordability, then that is, there's no 60-year period. It is permanently perpetually affordable, and that's a concern for us. We don't. Probably what their assumption is that they're going to apply to the state for financing in the future to rehab their project. But all the projects are perpetually affordable. Even right now, we do not have funding to fund rehab of current projects. I mean, that's a problem for us right now, where we didn't award any funding for rehab this past year, even though we had several projects applying. So as the number of projects grow, that problem is going to continue to grow. So there's no easy answer to this.
And so currently, if there is no permanent affordability requirement and the affordability period ends after 60 years, then these projects are refinancing to do some maybe improvements on the project, and then they're going to market to pay off their new refinanced debt.
That's correct.
But they're aging units, so likely lower rents than you'd expect from a brand new building.
Yes, I mean, they're typically under 80% AMI. That is what the market rent would be.
Yeah.
It's under 80% AMI.
Thank you, appreciate it. Representative.
On the other element in the bill, I also has to de-emphasize project readiness. How I understand the downsides or trade-offs to that, slowing housing delivery, but are there any benefits, like maybe preferencing mission-driven nonprofits or smaller developers, or what's the trade-off there?
Right now, we emphasize project readiness because we don't want, state funds to be sitting idle. We don't want to award a project funding and then wait, 3 years for them to break ground. So if you were to just take that criteria out, it would be allocated to other criterion such as, deeper affordability or amenities of the project. Yes, that would be a concern for us because we're always looking at ways to provide housing quicker.
Thank you.
Thank you. Members, further questions? Representative Cochrane.
Thank you, Mr. Minikami. So, I'm happy to hear that you said you don't wanna wait for 3 years for things to break ground. I think I mentioned, the lots that are under HHFDC and HPHA purview in Lahaina since the fire are sitting idle. So, I'd like, to see those words put into action. I'm reading in the preamble how the rental housing revolving fund has gotten well over $1 billion. And it's the largest line item only after emergency and in the budget. So saying, as the years progress, there's not enough funding, things can't, stay afloat, that's a lot of money that's been given to your division and department specifically. So I'm not understanding. So perhaps a working group, this is why they're calling for a working group here, to reassess and figure out, where the shortfalls are or the inefficiencies are or something. And I think to follow up with the question, Chair, I'd like to, how are you or do we need this working group maybe to look into avoiding the situation that happened with the Front Street Apartments in Lahaina? That Light Tech project, you recall what happened there?
Yes, we already addressed that situation.
Right.
The developer used a loophole to, get out of his reportability commitment early. We've already addressed that.
But moving forward, with all these Light Tech potential developments, to not just that loophole, but as you're saying, down the road, if we keep it in affordable perpetuity type concept, it's just not feasible, which I beg to differ, but, so just kind of looking at.
I'll note that, yes, RHRF has received about $1.1 billion in the past 10 years. It's also delivered more than 10,000 units. So it's about $100,000 per unit, which is a pretty good return on the state's, financing.
Okay, anyways, Chair, so thanks.
Thank you. Members, further questions? Seeing none. Next item on the agenda is HB 1920 relating to the low-income housing tax credit. This clarifies that a partner or member that is a partnership or limited liability company that has been allocated a LIHTC credit may either further allocate the credit or transfer, sell, or assign all or a portion of the credit to any taxpayer and extends the sunset of Act 29 relating to the low-income housing tax credit until 12/31/2022. Vice Chair for the testimony.
Department of Taxation with comments.
Department of Taxation stands on its testimony.
Thank you. HHFDC in support.
HHFDC stands on its testimony support.
Thank you. NIAP Hawaii in support.
Vice Chair, we stand on our testimony in support.
Thank you. American Council of Life Insurers in support. Sugar Creek Capital in support on Zoom.
Thank you, Chairman and members of the committee. My name is Phil Gilman and I represent Sugar Creek Capital, an affordable housing investor. I'm testifying in support of House Bill 1920. The Hawaii Housing Tax Credit is a longstanding proven tool to boost affordable housing supply, and continuing to foster this kind of robust market of investors is good public policy for Hawaii. This bill strengthens the demand for these housing credits in the investor market, which will in turn boost investment directly into these developments and help lead to more homes being built. Thank you for allowing me to testify in support of 1920. I'm happy to answer any questions.
Thank you. AARP Hawaii in support. Not present. And one individual with comments. Anyone else online or in person wishing to testify on HB 1920? Seeing none, Chair.
Members, any questions? Seeing none, next item on the agenda is HB 1812 related to housing. This establishes a 5-year Hawaii Builds pilot program within HHFDC. Authorizes HFC to utilize money from DERF for pre-development activities or as active construction equity, et cetera, et cetera. Vice Chair for the testimony.
Office of Planning and Sustainable Development in support.
Stand on our written testimony in support.
Thank you. HHFDC in support.
HSFDC stands on its testimony in support.
Hawaii State Council on Developmental Disabilities in support.
We stand on our testimony in support.
Thank you. State Procurement Office with comments. AARP Hawaii in support. One individual in support and one individual with comments. Anyone else online or in person wishing to testify on HB 1812? Seeing none, Chair.
Members, any questions on HB 1812? Seeing none, next item on the agenda, HB 1733 relating to the housing loan and mortgage program. Increases the Willamette multifamily revenue bond authorization ceiling amount to continue financing affordable rental housing statewide. Vice Chair for the testimony.
Office of Planning and Sustainable Development in support.
Stand on our written testimony in support.
Thank you. HHFDC in support.
HSFDC stands on its testimony in support.
Thank you. Hawaii Realtors in support.
Thank you, we stand in our testimony in support.
Thank you. AARP Hawaii in support. One individual in support and one individual with comments. Anyone else online or in person wishing to testify on HB 1733? Seeing none, Chair.
Members, any questions? Seeing none, next item on the agenda is HB 1715 related to affordable housing. Authorizes HHFDC to designate certain for sale units as permanently affordable housing subject to certain restrictions, clarifies that certain resale and occupancy restrictions apply only to projects developed prior to a certain date, and amends the definition of qualified resident for the purposes of HHFDC housing development programs. Vice Chair for the testimony.
Office of Planning and Sustainable Development in support.
Stand on our written testimony in support.
Thank you. HHFDC in support.
HSFDC stands on its testimony in support.
Hawaii State Council on Developmental Disabilities in support.
We stand on our testimony in support. Thank you.
Thank you. Hawaii Realtors with comments.
Thank you, we stand in our testimony.
Thank you. Mortgage Bankers Association of Hawaii with comments. Housing Hawaii's Future in support. NIAP Hawaii in support.
We stand on our testimony in support.
Thank you. The Democratic Party of Hawaii in support. And one individual in support and one individual with comments. Anyone else online or in person wishing to testify on HB 1715?
Members, any questions? Dean, I have a quick question. I think there's some confusion on how this would work. Could you just walk us through the current program and how this would change, how this would replace it as far as the restrictions bill?
Sure. Currently, when a project uses one of our 218 program, for example, and it's a for sale project, there are the 10-year buyback and the shared appreciation restrictions. So basically, in the 10-year buyback program, it must be owner occupied. If the home buyer wants to sell the property, we typically will purchase it back from the owner. 1% simple appreciation per year. So if they want to sell it after year 8, for example, we purchase it back, what they paid plus any capital improvements they put into the unit, and multiply by 8% basically. This has, been a hardship for certain buyers who are locked into a unit for 10 years. Circumstances change where some folks might get married, they have kids, they might need a larger unit. They're locked into the unit for 10 years. So under this proposal, someone who purchases a unit could sell it at any time. So there wouldn't be that 10-year restriction anymore. There wouldn't be shared appreciation. They could sell it, but the price would be based on an index. And what we're looking at using is the 40-year long-term appreciation rate for multifamily units on Oahu, which is about 4.5% per year. That's the 40-year average. So let's say after 5 years, someone wanted to sell their unit. They could sell it, But if we adopt this index, the Oahu index, it'd be 4.5% compounded per year for 5 years. So that'd be 20-something% appreciation that they would receive. And that's appreciation that they would keep, so that's their equity that they receive. There wouldn't be any shared appreciation, so they don't share anything with us. So this seems to be a middle ground where it allows home buyers to gain equity, but also the flexibility to move out of their unit when the needs change.
Thank you. And so just for clarity, so on the current 10-year restriction with the 1% appreciation, you guys would guaranteed buy the unit back if somebody wants out?
We don't guarantee that we buy it, but if not, then they have to sell it to another qualified resident.
That's still at 1% though.
Yes.
And then under this new program, it'll be in the range of 4%. You guys won't necessarily be buying them back. It'll go to market with a capped price of 4%.
Yeah, they could sell it to anyone at that indexed rate.
And then if, say, there's a higher AMI project out there over a 20-year period, it's possible that 4% might exceed market.
Then it's whatever the market bears.
Okay, members, questions?
Yeah, I have a question for Dean.
We're okay.
So Dean, let's say using your example, a family got into this affordable unit, and then their family grew, they had some kids, so now they wanna get a larger unit. In here it says the inability to own any other property. So would you folks take their current unit and sell it for them, or do they have to sell it first before they can get into another unit? And let's say they got into another unit, would you guys still mandate, or, you guys would have to mandate that they sell it, right? How would something like that work?
So part of this bill also, it does away with the first-time home buyer requirement. So someone could own a HHFDC unit and then move into another HHFDC unit. They don't have to be a first-time buyer anymore. They would have to sell their current unit, but they could move into another larger unit.
So I'm sorry, that was my question. They cannot have two units, they have to sell.
Right, because under this program, it has to be owner occupied. So in the admin rules, we could set forth that, if you currently own a unit, you have, say, 12 months or so to sell your current unit if you buy another unit.
And let's just say market takes a dump, and they cannot sell it, what would then happen?
We could always have the option to foreclose, which is not what we would want to do.
Wouldn't it be better for you guys to just buy it back? Foreclosing kind of hurts, goes against the whole situation of what we're trying to do and help, right?
So, buying it back or foreclosing basically is the same thing. If we buy it back, it's more of a voluntary purchase by our part.
Thank you.
Thank you. Representative Lechika.
Can you explain again how equity will be affected? Is there, for the homeowner, is there less equity for this new program, or how would that be?
Depends on how we look at it, and depends on how far below market the units are priced at initially. An example that I know of is, let's say, the Kaplani Residence project, where there were 100 units that were sold in 2018 for as low as $400,000. Currently, the one-bedroom units in that building are selling for over $700,000. So, in 2 years, all the units there will be market units. So folks can probably sell the units at $750,000 at that point. So yes, there'll be a lot of equity for the affordable buyers at that point. If we were to adopt that 4.5% index right now, the price for a one-bedroom unit that sold for $400,000 would be, I think it was about $520,000. So after 8 years, a home buyer would have gained $120,000 of equity, which they can use to purchase, their next home. So if looking at it from a buyer's perspective, you're not going to gain the windfall after 10 years, but you're still building substantial equity getting the same equity percentage-wise as an investor does when they purchase real estate.
And then would that unit remain at, the price for that unit would remain at 500,000?
No, it keeps on going up at 4.5% or so per year.
It just slows it down, but it doesn't trigger the market rate, is what you're saying, okay.
Sorry, quick clarifying question, for the changes to the definition of qualified resident, just expanding on Representative Muraoka's question, so currently, it is extremely difficult for somebody to purchase another restricted unit because they would have to sell their current unit within a year.
Well, currently, there is a provision where home buyers of restricted units can move to a larger restricted unit if their family's circumstances change.
Yeah.
But they must sell their current unit before they can purchase a new unit. So timing wise, it is just impractical.
So under the current system, it's essentially impossible for somebody to move up into a large unit as their family situation changes. With the changes to the definition of qualified resident here, where theoretically somebody could own 2 units simultaneously, it gives more flexibility for somebody to be able to purchase another unit while they work on selling their older unit. So the intention here is with flexibility, so somebody could move up that ladder into a bigger unit. Okay, thank you. Members, further questions? Representative Coffey.
You mentioned utilizing Honolulu Housing Affordability Index. And in this bill, it states or other reasonable affordable measures. Do you know what those could be?
We looked at neighbor island indices, but for Maui, for example, is very volatile. So it's hard to, if you look at the Oahu index, it's a pretty constant 4% rise. Maui is very volatile depending on, Maui's economy. So it could be the consumer price index, but we're looking at the Honolulu index because it's the most stable and it's probably most reflective of property appreciation rates statewide.
Chair, follow-up? Any other states? Because I know Colorado has been looked at many times in this affordable perpetuity because they've done it and have been doing it. Vail, resort town like Lahaina, resort town, like whatever, we have similar demographics. So did you folks look out of state actually?
We did look at the Vail program. California also has programs where they offer affordability. But this was really just looking at our programs, how we can modify our program to meet objectives of providing equity growth while also maintaining affordability.
Okay. And one last, Chair. So I've always, I like the direction this is moving, but do you, just a question I think for yourself too, do you think that we need to have 2 types of inventory of housing? You have your market investment type properties, which we have a ton and I think too much of, versus an inventory of this affordable, talking about perpetual or perpetuity type, affordability of housing. And that inventory we need to beef that inventory up to balance it out. Right now, I think we're over on the market rate and we're very low, obviously, in every preamble we're talking about housing, under in our affordability housing. So do you agree with that concept?
No, I think that is true, that right now there isn't really a market for Kama'aina. Because, everybody's competing in the same pool. Even for the restricted units, for most buyers, they're gonna hold on to that unit for 10 years. So it's not really available for households.
But sorry, along that line, but after 10 years, it flips into market. So now we just we're starting from square one again. So we lost that inventory on affordable housing. That's where I'm going with that.
Mm-hmm.
So for me, perpetuity and perpetual type concepts have to be implemented, so anyways, thank you, Mr. Minikami.
Thank you. Members, further questions? Seeing none, next item on the agenda is HB 1723 relating to the rental housing revolving fund. revises the mixed income sub-account within the rental housing revolving fund by modifying the priority list for project funding and adding new project priority criteria, and authorizes transfers into and out of the account. Vice Chair for the testimony.
Hawaii Public Housing Authority in support. Thank you. HHFDC with comments.
We stand on our testimony and support and offering comments.
Thank you. Catholic Charities Hawaii with comments.
Aloha Chair and Vice Chair, I'm Betty Lou Larson, representing Catholic Charities Hawaii. We support the intent of this bill. I think we feel that the state needs both for sale housing and, of course, rental housing. However, there needs to be a separate process for sale housing. Mixing it up with the rental housing revolving fund, we feel is not the right direction. Using something like DERF or an equitable mechanism would really provide a transparency. It would provide a framework for the for sale affordable homeownership. That needs to be addressed, has to be creative, but also has to be clear to the public that this is for home, for ownership and how they can participate, how they can provide input, etc., like that. So we just encourage you to separate these issues so that there is no confusion between the state's efforts for the for sale, which is a new, I think, initiative, and the long-term initiatives for rental housing, which has been going on for the past 20 plus years. So we thank you for allowing us to give our comments.
Thank you. The Nature Conservancy with comments. Housing Hawaii's Future in support. And AARP Hawaii in support. Anyone else online or in person wishing to testify on HB 1723? Seeing none, Chair.
Members, any questions? Seeing none, next item on the agenda is HB 1724, relating to the Hawaii Housing Finance and Development Corporation. Makes the DERF Equity Pilot Program permanent and expands the use of proceeds in the dwelling unit revolving fund to include purchasing equity in for sale housing development projects and interim primary or secondary financing. Vice Chair for the testimony.
HHFDC in support.
We stand on our testimony and support.
Thank you. Office of Planning and Sustainable Development in support.
Stand on our written testimony in support.
Thank you. Hawaii Appleseed Center for Law and Economic Justice in support. Housing Hawaii's Future in support. AARP Hawaii in support. Hawaii Community Foundation in support. Anyone else online or in person wishing to testify on HB 1724? Seeing none, Chair.
Members, any questions?
Question
Representative Lachika.
for HHFDC. How much would we need to allocate? What is our current, in terms of applications and the amount that's currently capped or the amount that we have? What's the gap in terms of how much, if the legislature had an unlimited amount of funding, how much would we need to allocate to address
We don't have to allocate any funding to make the program permanent. We would use our existing DERF funds to continue funding this program. Generally, under the pilot, we had $10 million to allocate, and the amount has been roughly about $100,000 per unit. Making the program permanent has the additional benefit of being able to pair loans out of DERF, so we can put our funding in earlier to help with project feasibility of these for sale projects. And instead of paying back the loan, we take equity in the units. So that's a way to really get some projects off the ground where they're struggling because they don't have enough equity to start construction. So they can be basically an equity investor to get the projects moving.
Do we currently have, beyond the authorized 10 million, do you anticipate that there's more that's beyond, that I guess could be allocated beyond the 10 million?
Yes, I mean, the program has been quite popular with home builders, so we anticipate that going forward, that there will be continued demand for the program.
Do you know what the current amount is for the number of applications?
We went through the $10 million in about 2 years, so it depends on the pace of construction, but I think 5 million per year is something that is probably achievable long term. Again, this is something where the state gets paid back its equity plus shared appreciation when those home buyers sell their units. And typically home buyers, first-time home buyers especially, tend to sell their units in about 10 years.
Do you need any additional staffing to manage this in this new kind of model?
Our current staff have stepped up and are implementing this, so we seem to have it under our belt right now. So right now it's going okay.
Thank you, thanks for putting in this measure.
Good bill. Thank you.
Sure.
Representative Cochran.
Mr. So this started out as a pilot and now this is seeking to make a permanent aspect strictly out of your HHFDC. Is that what this is? And so you folks will have sole control of the funding and determining, I guess there's a portion, equity percentage share, the appreciation share, I think maybe that's what was discussed earlier in the last bill maybe, the index. Is that what that is speaking towards?
For this program, we do want to have an equity percentage share to make sure that the program is fiscally responsible. So if the state is putting in $100,000 of equity into a unit to lower the price paid by the home buyer, well, that's actually the state's equity, that's not the home buyer's money. So the state should be able to receive a return if the unit appreciates.
Right, okay, and that's where I think, to figure out what that number is to make this a revolving per se type fund. Or on the flip side, what's put into the DERF could be tying up funds maybe too, if it's over, if too much is asked for, or, in the initial stages, I suppose. Once it's rolling out, you can gauge more what's needed, not needed, I guess.
That's why we're not asking for funding for this program. We have sufficient funds in DERF, so we'll just use those funds for this program.
Okay, and was that 10 million stated? You said in the last 5 years, 2 years you've used 5 million per year?
Yes.
Is that the amount? And that's again what you wanna start with?
Well, we have existing funds in DERF.
And
so
that
we're
is, what's the existing total this time? Was that stated?
Because the cash balance is about $30 million. We also have $50 million from an infusion, so we do have funds for this. And we're balancing this with other funding needs also, so. But we would use whatever sources we have available for this program. I'm not asking for any additional funding.
Okay, and then Chair, I don't know if, but at the end of this bill, it says it takes effect 3 years back, 2023, or do I need glasses?
That might have been the
What does that
original
mean?
pilot program.
Is that, shall take effect on July 1st, 2023? Is that by amending that, sorry, I did need glasses, sorry. Okay, sorry. Okay, thanks, sorry, thank you, Mr. Minakami.
Thank you. Members, further questions? Seeing none, next item on the agenda is HB 1727 relating to the rental house revolving fund. This allows for transfer of funds from the RHRF to a sub-account and between sub-accounts of the fund. Clarifies what constitutes a mixed income rental project for purposes of loans funded through the mixed income sub-account. Repeals the sunset date for the mixed income sub-account, authorizes the Director of Finance to deposit rental housing revolving funds into the mixed income sub-account and appropriates funds. Vice Chair for the testimony.
HHFDC in support.
Please stand on this testimony in support.
Thank you. Catholic Charities Hawaii with comments.
Aloha Chair, Vice Chair, I'm Betty Lou Larson with Catholic Charities. We definitely support the need for rental housing for the workforce. So we support the intent of this bill. We just raised the comment that we want to make sure that there remains a balance between the focus on the under 80% AMI, the population that really is at risk for homelessness a lot, our kapuna who are increasingly becoming homeless and just need to have affordable rentals. So the balance in funding to make sure that both important initiatives move forward. And not one at the expense of the other. So that's our only comment. Otherwise, we support the intent of this bill. Thank you.
Thank you. Housing Hawaii's Future in support. Hawaii YIMBY in support. CARES in support. On Zoom.
Yes, hello, can you hear me?
Hi.
Okay, Angela Melody Young cares in strong support. I think what this bill is trying to do is to facilitate the transfer of funds for the rental housing revolving fund. And so it specifies the conditions upon which the HHFDC may transfer. And I think this legislation is designed to accelerate development of affordable rental housing in Hawaii by providing HHFDC with greater financial flexibility and a permanent funding mechanism. And by allowing HHFDC to transfer funds between accounts without legislative approval, repealing the sunset date on the mixed income sub-account, it can streamline the financing for projects to help. I think what it's trying to help is the tier 2 category, the classification of the middle class families in this income range of 60 to 140 AMI. And so the legislation, I think, is really helpful for the rental housing revolving fund, which is in high demand, often hitting its funding caps, which encourages the development of these alternative, diversified, and mixed income housing strategies. So this is really helpful. I think it should be enacted in good faith to develop housing.
Thank you. Anyone else online or in person wishing to testify on HB 1727? Seeing none, Chair.
Members, any questions? Seeing none, wait, give me 1 second. Next item on the agenda is HB 1711 relating to housing. Amends for purposes of the Hawaii Housing Finance and Development Corporation's rent-to-own program, the period during which the sales price of a dwelling unit is required to remain fixed from 5 years to an option period to be determined by the corporation. Vice Chair for the testimony.
HHFDC in support. Thank you. Housing Hawaii's Future in support. And one individual with comments. Anyone else online or in person wishing to testify on HB 1711? Seeing none, Chair.
Members, any questions? Seeing none, we will brief recess to get quorum for decision making. Reconvening our Housing Committee public hearing for decision making for our 9 AM agenda. We already DM'd on HB 2611 and HB 2102, so we're moving on to HB 1710 relating to historic preservation. I recommend that we move on to HD 2 and that we ensure that subsection B in 60-42 is consistent with subsection B in 60-10 regarding review and concurrence timeframes. And that will, I recommend adding language to the end of subsection B in 60-10 that clarifies that the project may move to the next step in the compliance process. Members, any questions or concerns? Seeing none, Vice Chair for the vote.
Voting on HB 1710 HD 1, the recommendation is to pass with amendments. Chair and Vice Chair vote aye. Representative Cochran.
Reservations.
Representative Grandinetti.
Aye.
Representative Kila.
Aye.
Representative Kitagawa.
Aye.
Representative Lachika.
Aye.
Representative Muraoka.
Aye.
Representative Pierick.
Aye.
The recommendation is adopted.
Thank you, Vice Chair. Next item on the agenda is HB 1868 related to housing. I want to note HHFTC's concerns in their testimony with mandating QAP changes in statute. And I'll quote them. We respectfully note that prescribing detailed QAP criteria in statute may limit the ability of the federally required public process to meaningfully inform the final plan. This creates tension between legislative direction and federal compliance obligations. Also of note, and I share their concern that this is a little bit cart before the horse, and Dean might have used that term that I'm copying, but the idea that we are mandating what the changes are and then creating a working group to implement those changes. And also, I have concerns with mandating permanent affordability for the reasons that we discussed today, and that I think it is important to ensure that projects can refinance at the end of their 60-year period. These things are going to be going to market, but they'll be much cheaper units because they're old. And I think that we are obligating future state funding by requiring permanent affordability. I also think that we are really giving a huge boost to government projects when you have mandated permanent affordability at the expense of some private projects. And government projects are great, permanent affordability government projects obviously are great, but it's not, we don't want all projects to be government. For example, in Louis, there's not a lot of government land there, those can be private projects. So we need, where I'm from, we need to ensure that the private sector can develop these also. So my recommendation then is to delete the reference to members of the move on to HD1, and we'll delete the reference to members of the working group not being subject to Chapter 84. As the Ethics Commission has already stated that Chapter 84 does not apply in these circumstances. I recommend that we delete paragraphs 1 and 2 of the preamble. I recommend that we delete the third sentence of paragraph 3 of the preamble. I recommend that we delete sections 4, 5, and 6 of the bill entirely. I recommend that we defect the date, and I recommend technical amendments for clarity, consistency, and style. So essentially what we'll be doing is creating a working group. We're not going to explicitly spell out how the working group is supposed to do their work. Let them figure it out as a working group should. Members, any questions, comments, or concerns? Yes, Representative Kennedy.
Thank you. I actually participated over the interim in a community process on the QAP led by Appleseed and Poverty and Race Research and Action Council. And it was really cool to see how the QAP can be utilized as a tool for deeper community engagement. So I kind of think, just echoing the fact that that public process is really important, and that if we do it right, it can bring in sort of new voices, and people are trying to do that around the country. So I understand the kind of intent behind the working group, but I also think that we can improve that public process.
Yeah. Thank you for comments. And actually, based on that, I do want to note in the committee report that the intention of this is to improve public input and public process through this. I know that QAP already has an extensive public input process. Mm-hmm. If we're replicating that work through a working group, we need to ensure that we have extensive public input, and that it's not coming at the expense of public input. So thank you. Rep. Lachika?
So Chair, just to clarify your amendments, you're removing section 5.
Section 4, 5, and 6.
4, 5, and 6, so all the, the restrictions on, prescribing the QAP, the perpetual affordability requirement and tying that to the funding.
Yeah.
Okay,
So moving forward, a working group, but we're not defining exactly what the working group is supposed to be making.
Okay.
Okay, members, further questions, comments, concerns? Seeing none,
Chair,
by,
wait, real
yes,
quick, I'm sorry,
Representative Cook.
the makeup of the working group stays the same?
Yes, not touching the makeup of the working group yet. Seeing no further comments, Vice Chair for the vote.
Voting on HB 1868, the recommendation is to pass with amendments noting that all members are present. Any members voting with reservations?
Chair, Vice Chair, myself.
Reservations for Representative Cochran. Any no votes? Seeing none, the recommendation is adopted.
Thank you. Next item on the agenda is HB 1920 relating to the low income housing tax credit. I recommend that we move on to HD1, that we adopt the recommended amendment from Doe Tax's testimony, that we make it applicable to taxable years beginning after December 31st, 2026, and that we defect the date. Members, questions, comments, or concerns? Seeing none, Vice Chair for the vote.
Voting on HB 1920, the recommendation is to pass with amendments. Any reservations? Any no votes? Seeing none, the recommendation is adopted.
Next item on the agenda is HB 1812 related to housing. I recommend that we move out in HD1, that we respect the date, and that we note in the committee report the concerns from the Office of Procurement, and we ask them to address those concerns if necessary. Members, any questions, comments, or concerns?
Request, on that last vote, am I allowed to come as a no?
I'm gonna go back.
Yeah, if we already voted, sorry. Questions, comments, and concerns on HB 1920? Seeing none, Vice Chair for the vote.
No, Chair.
Oh.
1812.
Oh my gosh, yes, 1812. Sorry, HB 1812. Seeing none, voting on HB 1812.
Good.
Yep.
Voting on HB 1812, the recommendation is to pass with amendments. Any reservations? Any no votes? The recommendation is adopted.
Next item on the agenda is HB 1733 relating to the housing loan and mortgage program. I recommend that we move on to HD1 with a defective date, and then the Attorney General submitted testimony on the Senate companion for this bill, recommending some language changes for clarity. So we'll be adopting that language, which will be replacing the $5 billion Hula May multifamily revenue bond authorization with, quote, aggregate principal amount authorized under this section, and tech amendments as necessary. Members, any questions, comments, or concerns? Seeing none, Vice Chair for the vote.
Voting on HB 1733, the recommendation is to pass with amendments. Any reservations? Any no votes? Seeing none, Chair, the recommendation is adopted.
Thank you. Next item on the agenda is HB 1715 relating to affordable housing. I recommend that we move out in HD1 with a defective date. Members, any questions, comments, or concerns? Seeing none, Vice Chair for the vote.
Voting on HB 1715, the recommendation is to pass with amendments. Any reservations? Any no votes?
Reservations.
Reservations for Representative Pierick. The recommendation is adopted.
Thank you. Next item is HB 1723 relating to the rental house revolving fund. I recommend that we move on to HD1, that we delete the changes to subsection F on pages 2 and 3 while retaining the changes on page 4 in paragraphs 4 and 5. That we recommend adding language allowing for the transfer of funds into and out of the sub-account from page 1 of HB 1727. So essentially we're just using what I think is better transfer language from 1727 and eliminating the transfer language that's in the bill currently. And then also eliminating language around for sale properties. Tech amendments as necessary, and we will be defecting the date. But if you can give me one quick second to confirm. Yeah. Okay, members, any questions, comments, or concerns? Seeing none, Vice Chair for the vote.
Voting on HB
Wait, hold on, sorry. Sorry, my bad. Additional two amendments. We'll be deleting the for sale language in paragraph 4 in subsection F. And then we'll delete all language relating to the transfer into and out of the sub-account and replacing it with, again, page 1 from HB 1727 related transfers. Okay. Any questions, comments, and concerns? Vice Chair for the vote.
Voting on HB 1723, the recommendation is to pass with amendments. Any reservations? Any no votes? The recommendation is adopted.
Thank you. Next item on the agenda is HB 1724 relating to the Hawaii Housing Finance and Development Corporation. I recommend that we move on to HD1 with a defective date. Members, questions, comments, or concerns? Seeing none, Vice Chair for the vote.
Voting on HB 1724, the recommendation is to pass with amendments. Any reservations? Any no votes? Recommendation is adopted.
Thank you. HB 1727 relating to the Rent House Revolving Fund. I recommend that we just change the word chapter to part throughout. Check amendments as necessary, and we'll detect the date. Members, questions, comments, or concerns? Oh, and sorry, yeah, and blanking out the appropriation. Thank you, Vice Chair. Members, questions, comments, or concerns? Seeing none, Vice Chair for the vote.
Voting on HB 1727, the recommendation is to pass with amendments. Any reservations? Any no votes? So now the recommendation is adopted.
Final item on the agenda, HB 1711 related to housing. I recommend that we move on to HD1 with a defective date. Members, questions, comments, or concerns? Seeing none, Vice Chair for the vote.
Voting on HB 1711, the recommendation is to pass with amendments. Any reservations? Any no votes? Seeing none, the recommendation is adopted.
Awesome, thank you, members, for successful committee hearings. Seeing no further business, this hearing is now adjourned.